at the end for questions or comments or anything like that. So the first person that's going to be presenting tonight is going to be Fulton County Superior Court Chief Judge, Judge Brasher. And then he's going to be followed by Chief Judge Cassandra Kirk. And then we'll have Christopher Porter, Chief Judge Christopher Porter, forgive me, Your Honor. And then he will be followed by Chief Judge Juliet Scales. So I'm looking forward to hearing from everybody. And I again, thank you for being here. And I just want to get started with Chief Judge Christopher Brasher.
Thank you. Good evening, everyone. Thanks for the opportunity to come before you. It's a pleasure to see many folks who I've known for quite some time and to meet those of you I haven't met before. My name is Chris Brasher, and I'm the Chief Judge of the Superior Court of Fulton County. I've been on the bench for 16 years. I served before as a prosecutor and then as an assistant attorney general for the state law department, representing law enforcement for about 12 years before I was appointed in 2006. My intention tonight is to really cover three things. Who is the Superior Court and what does it do? What is our present situation and what is our outlook for the future? Obviously, if there are questions, I'll entertain those after we speak. The Superior Court is the highest level of trial court in the state. The Superior Court tries all felony cases. We also try all cases involving title to land and other equity cases, and we try all family law cases. So divorces, child custody, et cetera, mostly go to the Superior Court. What we're here to talk about tonight is the criminal cases, because even though the criminal caseload represents about 50% of our total number of cases, it represents about 90% of the trials that occur in Superior Court. So the majority of our trial time, the majority of our in-court time is spent dealing with felony criminal cases. The Fulton County Superior Court is the largest trial court in the state. We have 20 judges who preside over dockets, and we have about 200 employees that work for the court, a total budget of about $50 million, some of which is paid for by the state and some of which is paid for by Fulton County. So what is our present situation? Well, most of what I'm going to talk about is directly impacted by what has happened to our society, much less to the court system over the last 2 years, and that's COVID-19. In March of 2020, I signed the first emergency order in the state declaring a judicial emergency in Fulton County because of the spread of COVID-19. We had gone from a situation where basically 2 to 3 weeks earlier, we were going full steam to a dead stop on the 13th of March. It took about a year before we got started back again. We started trying cases again in person. And when I say trying cases, I mean trying jury trials in person in April of last year. So from March of 2020 to April of 2021, everything we did was virtual. We were handling criminal cases from the jail. We were handling civil matters. We were handling domestic matters, all virtually via Zoom. We purchased 50 Zoom licenses the week after the statewide judicial emergency in mid-March of 2020. We now have about 10 times that many. We've built out jail Zoom rooms at the jail. We've built out pods throughout the courthouse to use for Zoom. All of our courtrooms are outfitted now for hybrid proceedings, so we can do things either virtually or in person or a combination of them. That's really the only thing that kept us going for a year, was the ability to handle things virtually via Zoom. Fortunately now, as I said, we've been back to trying cases in person for about a year. We have tried over 100 civil cases where we've picked juries via Zoom. And the reason we've been doing that is because we've dedicated all of our in-person jury selection to selecting juries in criminal cases. But of course, the capacity has been very limited because of social distancing, because of all the other requirements under COVID protocols. We've had to be very deliberate and purposeful about getting people into the building, how we pick juries. We have two large courtrooms on the first floor of the Justice Center Tower, and we use those to pick juries from folks that are spread out in the courtroom so that we can social distance. We're still doing masking and some social distancing in the courthouse. You may look around in your neighborhood and say, why are you doing that? We're back to normal now. Well, the reality is that our stewardship of the authority to make people do things requires us to be very careful about that. So when you make people come to jury duty, you have to pay attention to their sensibilities. And people need to feel comfortable when they come to the courthouse. We're responsible for them, and we need to make sure that we're treating them fairly and that we're keeping them safe. So all of that means that our capacity has been limited, and with that comes backlogs. And so what are we doing about it, and what's our prognosis for the future?
That's
Well,
what
Fulton
we were
County-
interested in.
Say again?
That's what we're
Good. So what are we doing about it, and what's our prognosis for the future? So Fulton County has received about $75 million in ARPA funds, the American Rescue Plan Act funds, for the criminal justice system. That money is designed to increase the capacity of our court system by 25% for the next 3 years so that we can work through the backlog of cases. When I say backlog, what do I mean? Well, when we started in 2020, we had some backlog of cases already. We've decreased the pending felony criminal caseload by about 1/3 since then. Well, that sounds great, except that the pending unindicted criminal cases now number about 12,000. So what that means is there is a backlog of cases that need to be processed through the criminal justice system, through the grand jury, to be indicted, to come before superior court judges, and to either be resolved with plea or resolved with trial. So that represents basically 3 years worth of cases that are backlogged awaiting indictment. I understand from the district attorney's office that they expect to indict 9,000 cases this year. That would be about a 50% increase in what was indicted last year. So understanding that, what are we doing to address that increase in volume? Well, we've hired additional assistant district attorneys, assistant public defenders, investigators with the sheriff's office, sheriff's deputies, investigators with the DA's office and public defender's office. We've hired additional court staff, and we're bringing on senior and retired judges so that they can try cases. And again, our intention is to increase the capacity of the criminal justice system by 25% and to sustain that increase for 3 years so that we can work through the backlog. The reality is that the $75 million that we've received should be compared to what the rest of the state has received. And the rest of the state has received $98 million. So 158 counties are vying for their piece of $98 million, and Fulton County got 75. That's great, except that our numbers are an order of magnitude higher than any of the rest of them. And so we're trying very hard to get all those things going. Of course, the challenge is that we expected to be back at full bore by now, and we're not. Nobody is. The police departments, the sheriff's office, the district attorney's office, the public defender's office, all are struggling to hire people, just like every other industry is struggling to hire and retain talent. So in addition to the setbacks that we've had because of COVID, we've also had the great resignation that has affected our hiring practices just like everybody else's. All that being said, we're optimistic. We're optimistic because we have resources in a way and at an order of magnitude that we've not had before. And we have the commitment of the county, the commitment of the sheriff's office, the commitment of the district attorney's office, the commitment of the public defender's office, the courts, police department, to move these cases through the system as quickly as we can. Now, our charge in the Superior Court is to do that, to move those cases through according to the law and within the bounds of the Constitution. And so I'm happy to report to you that we've got resources, we've got will. Now what we need is a clear path. And when I say clear, I mean no more COVID setbacks. We need to get back to it, because if we start tomorrow with full capacity, it's going to take 4 years for us to get through this. And when I say that, I'm echoing what experts all over the country have said, that for a court system, it's going to take 2 times as long to get out of a backlog that's created than the time that you spend building it up. So hopefully, with the resources that we have received and the support of the community, we can move those cases through so that they can be adjudicated as they should be.
Yes,
that's my
Chief
presentation.
Judge,
Sure.
Chief Judge, what
Yes.
I'm interested in, and the reason we set up the Buckhead Public Safety Task Force, is I would like to hear from all 4 judges today, chief judges, what is working, what is not working, not COVID, but how many people are being held? Is there a backlog that is causing any one of these courts particular issues that we legislate, that we can make recommendations on? We have on this call state, county, and local law enforcement officials. And so I wasn't clear because we got going so fast, but that's what I'm asking each of the chief judges to do tonight, along with our chair lady, who is truly in charge, is to let us know what we need to do, because we will report out in May what we believe are the most important things that we can do to get Buckhead safer. And so anything that you can tell us tonight or that we can do in the questions at the end will be most helpful.
Okay, well, I think I've outlined most of the backlogs already, because the reality is that even though our pending caseload has gone down as far as felony criminal cases that are indicted, the unindicted cases outnumber that by 3 or 4 to 1. So what does that mean for us? It means that when we started this process in 2020, we had a jail that was at capacity with 2,500 people in it. Now we have a jail that's about 700 people over capacity. So we went from 2,500 to 3,200 people in the jail. When we started in 2020, we had 90% of the inmates in the jail had been indicted already. Now only 40% of them have been indicted. The last time the jail population was as high as it is now, we had a federal monitor imposed on us by the federal courts that lasted for 4 years and cost about $25 million. And we were no safer at the end of that than we were at the beginning. But the reality is that we have a backlog of unindicted cases, a backlog of indicted cases, and a limited capacity with which to move them. So that's our situation presently. Our outlook is that as soon as we can get all of those things operating at the same time, all the people hired, all the courtrooms up and running, we've got space, we've got technology, we've got people lined up, we've got prosecutors, defense attorneys, sheriff's deputies, all of that ready to go. We just need to get cases teed up and ready to try. So that's where we are.
Thank you.
I'm happy to entertain questions if folks have them. I'd be more than happy to do that.
Well, Chief Judge, at the time that you're adjudicating a case and you ultimately come to the point of sentencing, do you know what the capacity of, the place you're going to send them at that time? Or is that something that's just handled beyond you?
Well, let's take a scenario where someone is going to be sentenced for a serious violent felony offense. They're going to go to prison. They're going to be sentenced to a term of years in the state prison system. They'll go to the jail and then be picked up by the Department of Corrections, usually within about 60 days. And then they'll be processed through intake with the Department of Corrections and serve whatever the time is. Most violent felonies have a mandatory minimum period they have to spend in prison before they're eligible for parole. Of course, then they may be considered for parole by the parole board. If we're talking about somebody who's going to be put on probation or sent into a program, often someone is going to wait if we're going into a program such as a residential treatment center operated by the Department of Corrections or the parole board. They'll wait in jail until that is ready to happen. If they're getting a straight probated sentence, they'll be released and subject to monitoring by the Department of Community Supervision. That can be anything from house arrest, could be ankle monitors, other monitoring, could be close supervision where they have to report multiple times a week. taking classes, drug tests, etc. So it depends on the nature of the sentence, but they're going to either go back to jail and wait on the punishment to occur, whether it's in the prison system or some other program, or they're going to be released to the custody and supervision of the Department of Community Supervision.
Are you notified all along this process of any changes or any differences that happen after you've made the initial sentence?
So probably, I'm not sure that I understand exactly what you mean by that, but the reality is that once we sentence someone, there's an order of the court that says, this is what's going to happen to that person. And we may be notified if, for instance, something untoward happens and they can't go to the program or it gets shut down or something like that. That's one of those things that happened during COVID. We had things that were coming and going, et cetera. But as far as if they're sentenced to confinement time in the prison system, they're just going to be taken as a matter of course to the prison system. We would not get notification. The only time we'd get notification after that is if they were released on parole.
Okay. Thank you.
Sure.
Judge, could I ask, there's 12, you said there's 12,000 unindicted criminal cases. What method do you choose when you start to indict those? I mean, is it a FIFO, a LIFO, or is it based on the type of crime, or how does that work?
Well, I can offer you my observation as an outsider to that process, because those are not my cases to indict. That's the province of the district attorney's office, and they're working very hard to get those cases indicted. And my observation is that they began with the most serious cases. They began with murder cases and other 7 deadly sin cases, and they're working through those. That's one of the reasons why the number of indictments has been relatively low, is because the cases that they have been presenting to the grand jury are the most complex cases we have. They take the longest to investigate. They take the longest to put together as far as being able to present and then to actually present to the grand jury. So that's one of the reasons why that's taking a while to go through. I see Mr. Geary from the district attorney's office is here, and I think he has a point of order.
And the judge has been kind enough to let us run 2 concurrent grand juries. We're about the only office in the state doing that. So we're not running a single grand jury. We're running 2 grand juries at the same time. And it's about, as they would say, to cavitate the pump. We are putting them up as fast as we can prepare them adequately and properly. And we're increasing the time almost every week that the grand jury has to stay, because we're getting more and more and more cases. We are not currently on pace for our 9,000, but we are increasing every week such that we still anticipate and hope that we've got 9,000 cases processed this year. But of course, as the judge said, as we're putting them out one side, they're coming in the other side.
Thank you.
I hope I answered your question.
Yes, that did. Thank you very much.
Thank you. Okay, so if that's it for you, sir, Chief Judge Brasher, the next person, if she's ready, I think she is, Chief Judge Cassandra Kirk. Thank you for being here tonight.
Hi, thank you for having me. And I signaled to Mr. Elgar that I do have a presentation I would like to share. So if he would give me that capability.
Is it a PowerPoint?
It is.
There you go.
So yep, I think I am here. To the chair and members of the task force, good evening. Thank you for allowing me the opportunity to speak with you all today. I'd like to, as Judge Brasher did, share exactly who the Magistrate Court is, what it is we do, and how it is we are directly connected to the question that this task force has for us. My name is Cassandra Kirk. I serve as the Chief Magistrate Judge in Fulton County, and so I'd like to begin with an overview. I believe that the Magistrate Court is new to many of you. It is not the court that you have heard from many, many moons ago. This court in this iteration was formed in 2012. Actually, legislation came down in 2013, 2013, 14. And then I was appointed by Governor Deal. There is one elected chief magistrate judge that chief title sticks with that individual for the entire 4 years of his term. At this point, it's me. And then that person is responsible for appointing the other judges as well as assigning the other judges. You all know, or you may know, that both state and superior court have an approval over which judges get to sit for the magistrate court. In 2015-16, there was additional responsibility given to the chief judge, and this is a court that has been created. Currently, the court structure is that we operate 24 hours a day, 7 days a week, 365 days a year. This is not a court that shuts down. We have people on duty now. We will have people on duty late this evening, and our law enforcement can testify or can attest that many of our judges will be up with them later this evening. We operate across 9 locations. We operate 9 courtrooms across 4 locations. There are a team of 30 judges, 8 full-time, 22 part-time. We only have 3 judicial assistants, 2 law clerks, and a lot of what we do really depends on the number of interns that we have. And I think Judge Brasher alluded to this. I'm unsure if you all can see my screen. So when we all came back, there was a consultant that the county hired. In 2021, the consultant projected numbers. These were numbers for both state court, superior court, magistrate court, but these were numbers that should have encompassed the backlog. So starting from 2019, the magistrate court prediction on those numbers was 173,000 cases. Magistrate court, unlike superior court, does not have jury trials. So we are able to move a little bit quicker than superior court is. When I talk about our jurisdiction, what magistrate court is known for, and I apologize, is our civil jurisdiction. The majority of what we do is our civil cases, small claims less than 15,000, garnishment actions, post-judgment, and landlord-tenant. What you all are interested in is our criminal jurisdiction. Search and arrest warrants, that's what we do 24/7, 365. We do first appearance 6 days a week, warrant application hearings, preliminary hearings, and one of the new pieces that has been added to magistrate court is a collaboration between our state court, our pretrial diversion, our public defender, and our behavioral health, and that's our misdemeanor mental health court. When we are designated by superior court, we also provide judicial assistance in the non-complex division, and that's something that we will probably speak about a little bit later. In terms of our numbers, I want to share with you the numbers for magistrate court as we have been talking from 2019, even to date. Our numbers in magistrate court, we have had 207,000 cases filed. We have cleared 176,000 of those cases. Again, we do not have jury trials, so it is a little, I don't want to say easier, but it is less cumbersome for us to place cases on a calendar. We still have the same capacity issues. We are having courtrooms that used to have probably 20 or 25 cases on a calendar that now only have 10 cases on a calendar. That has limited the amount of cases that we can handle. But as of today, actually, these are numbers from Friday, we have an 84% closure rate of our cases from 2019 to 2022. I want to talk to you all about those warrants. So this task force is more than likely concerned with violent crimes. I'd ask that our judges are the ones that generally do electronic warrants that were issued from January 1 to April 7th. So January 1, 2019 to April 7th, 2022. I want to bring those numbers up for you. For aggravated assault, almost 7,000 in that period of time. Armed robberies, 1,100. Murders, less than 1,000. Carjacking, 27. And then burglary, 1,529. I have a report that's about 600 pages. I just pulled out the violent felonies that would be of interest to this group in terms of what we're tracking and what you all are discussing. The next thing I want to share with you is what the map looks like in terms of how justice flows in Fulton County. I have highlighted in the blue specifically where the magistrate court plays a role in what it is that's going on. Obviously, we start at arrest. We also start after arrest. I apologize. We start at arrest, we move to first appearance. Because again, our judges that issue those warrants move to first appearance. Our judges sit right now, we only sit on felony first appearance. There is no misdemeanor first appearance. There is another calendar that happens for misdemeanors. Those cases are actually accused, and that is handled on a C calendar. The misdemeanor mental health court is where our judges sit, as well as copy of charges. Those are cases coming from citations from the police jurisdiction. Any jurisdiction can do that. The all-purpose hearing is a piece of the non-complex division. And so that is where magistrate judges also sit, specifically for the non-complex division. And bond decisions are made, obviously, at first appearance, at all-purpose, at plea and arraignment coming from non-complex. Our judges will also sit some felony probation revocations as we are designated. And again, in the non-complex division, we'll have trials. As it relates to bond, I know that is a question. There is the unsecured judicial release. I wanted to share and be transparent with this committee that we do have a checklist for when it is judges are able to actually issue an unsecured judicial release. And this is what used to be the sign-on bond, the signature bond. There is no longer a signature bond. If a judge chooses, or if a judge determines that the facts support the release of an individual either to pretrial services or on their own recognizance, the judge is now issuing an unsecured judicial release. Bond decisions are made the same way they have always been made. It is based on the law, based on the Ayala factors. And so I will also submit to this group that our judges train we train every second Friday on some aspect of what it is we have been doing. The magistrate judges' minimum criteria are those that match the minimum criteria for a superior court judge, so that we are able, once designated, to be able to sit in those seats. I mentioned to you all about our misdemeanor mental health court that began in 2018 as a pilot program, and that program is going very well. I want to lift up these collaborations, but lift up also the fact that we have had 64 graduates since we began. We have a less than 1% recidivism rate, and we have had 78% of those people that entered have actually graduated. Our last graduation was March 25th, and so this program is moving well. We accept individuals from the jail as well as from state court plea and arraignment, and as well as if there is someone that is identified at some point in the system before they take their plea, we will also handle those individuals. It is now a year-long program. It is state certified, and our coordinator, Georgie Corley, is actually a state certified coordinator. She is the only certified coordinator in Fulton County. All of the others will become certified as well. And I wanted to lift up Judge Patsy Porter, who was with state court, who was also involved in this program, as well as Shaka Douglas, who is the other magistrate that sits on this court. This has been my presentation. The magistrate court, again, is a team of 30 judges, and it is our goal to inform, engage, and empower our community. I am happy to take questions.
Thank you, Your Honor. Any questions from anybody?
Well, I know that there's been a great deal of concern, Chief Judge, about the unsecured judicial release. So I appreciate your informing this group as to how you're doing it. And I would appreciate your sending over to us for our May report what you think is working with that, what you think isn't, where there could be some changes, and if we should be advocating for changes. Just as with Chief Brasher, as I was the chair of the Council of Neighborhoods, we took a very strong stand about not closing down the Fulton County, the city's jail, so that it could be used with Fulton County. I know there's the diversion center there that is being put in there now, but there is, if we have an overcrowded situation and anyone is making a decision because they have to on capacity, I know that everyone that is involved with this task force wants to make sure we come up with better ways of resolving that. It's one of the strongest issues that I personally have, and I'm speaking as a councilwoman, not as the chair of this committee.
Yes, ma'am. And so I would tell you that the information flow has gotten better, and that has always been a cause for concern, but that has gotten better. And so that helps us make better decisions in terms of who should and who should not be released.
Good.
Thank you, ma'am.
Thank you.
Well, if that's all from everybody for questions, Chief Judge Porter, are you ready? I can't hear you. Your sound is off.
Yeah, absolutely. Glad to be here. We sent over a presentation earlier, so if you want to put that up, that'd be great. Good afternoon, good evening. My name is Chris Portis. I am the Chief Judge for the Municipal Court of Atlanta. You're looking at a title screen, so if we could move to the next slide, that'd be great. Just want to spend a few minutes talking about who we are, what we do, and how we do it. The Municipal Court of Atlanta is a court system that
Rick
handles...
Hamilton, you're on. You're on. Please mute. Sorry, Judge.
That's fine. So the Municipal Court of Atlanta is a court that hears primarily cases that are specific to the city of Atlanta, both inside of Fulton County and the parts of the city that are in DeKalb County as well. This includes all of the city ordinances that are passed, and the primary goal, overarching, of course, of the court is to be efficient, to have impartial hearings, fair hearings, and also provide a forum for individuals to be heard, both the folks that are concerned in the cases, as well as neighbors and residents who are impacted by some of the conduct. One of the main things that we attempt to do with all of the cases that we hear and resolve is to regulate some of the conduct inside of the city limits, especially as it pertains to the types of cases that we hear with ordinances and in particular, the traffic violations. Next slide, please. The slide you should be looking at, the slide numbered is 3, just some basic information about how the court is broken down. There are 6 basic divisions for the court. The General Traffic Division, which hears all of the traffic cases regarding things like speeding, suspended licenses, and all of the basic rules of the road violations. The In Custody Division that hears everyone who has been arrested and who otherwise needs to see a judge who has not been released as a result of the signature bond ordinance. The Restore Atlanta Division, which is an alternative sentencing portion of the court, primarily concerned with quality of life offenses, individuals who are under the ages of 21, as well as the Restorative Justice and Homeless Court programs. The Criminal and Aggravated Traffic Division, which hears all of the misdemeanor criminal offenses that come through the court for both ordinances and low-level state charges concerning drugs, shoplifting, disorderly conduct, fighting, hitting run, fleeing, and all of the offenses related to street racing. The DUI Division that hears all of the cases for driving under the influence of both drugs and any other intoxicant, and the Housing and Code Enforcement Division, which hears everything concerning all of the commercial and housing code, as well as any violation concerning any permit that is issued by the city of Atlanta. There are currently 10 full-time judges. The average caseload for new cases per judge is about 520 per week, and the average number of cases that the court will close per week is about 2,300. The court, because it is a non-jury trial court, has concurrent jurisdiction on all of the state offenses that it hears, both for the traffic offenses, which are all of the Title 40 offenses, as well as all state misdemeanors and crimes. So that means that in any of those cases, if a defendant wants to have a jury trial, we send those to the county for which the offense occurred, whether that was DeKalb or Fulton. The court has original jurisdiction on all of the cases that are city ordinance based, all of the civil traffic and parking cases, as well as the school bus false alarms and those types of matters. Next slide, please. This is just a snapshot of the volume for calendar year 2021 from January through December, just a breakdown of what the caseload actually looks like by proportion. The biggest portion of cases being the traffic misdemeanor cases, making up about 81% of all of the cases heard. Comparing that to a year 2019, the last full year before the COVID pandemic set in, total number of cases heard for that calendar year, 178,000. Between 2019 and calendar year 2021, that averages at about 150,000. Usually on a regular year, we will cycle through just short of 200,000 cases pre-pandemic. Averaging where we are now for 2022, based on the 2 pandemic years, we're now up about 30% for the first quarter on cases received. Next slide, please. Just some information about how we cycle through the cases. It's not just, fine or jail time for the cases that we hear, even though they are low-level offenses. We also try to route individuals through programming that hopefully will set them on a better path. So there are an array of programming that we use. The solicitor's office runs its own pretrial intervention program, which they have the ability as prosecutors under state law. The court for alternative sentencing runs programs such as Teens Learning Control, Restorative Justice. We have a substantial community service operation, and we also have the homeless court program. The TLC program for teens takes primary focus on individuals who are 21 and younger and provides information programming that hopefully will steer them to better decision-making moving forward. Restorative Justice looks at criminal cases for individuals who are primarily in the range of 25 and younger and tries to do the same thing for those type of offenses. We run for probation in a year like 2019 that was pre-pandemic, about 73 hours total between Restore Atlanta and probation, which is a significant amount of time spent giving back. And we cycle through a considerable number of individuals through our programs trying to educate them about life skills and decision-making. Next slide, please. Second program, big focus area for the individuals who interact with the court as well as our community partners in downtown Atlanta is our homeless court program. And that is a program that uses the traditional means of the criminal justice system to require individuals as a portion of resolving their case to connect with services and programming that are direly needed to try to break the cycle of homelessness, as well as break the cycle of continuing to involve themselves with the criminal justice process. We know that some of the individuals who are living on the streets, a main driver of them coming in contact with the court system, with the police, is not only homeless living, but mental health and substance abuse. So what we try to do with these cases, especially the ones who are repeat offenders who come through the jail system, is get them connected to these critical programs, and in many cases, get them connected directly from the hands of the correction staff to these other programs to try to break this cycle, whether that be getting them evaluated for substance or mental health, getting them back connected with the regimen of treatment that they need to maintain some level of stability, whether that's job skills, whether that is the need to be connected to even things like family that in some instances may be needing or looking for them, and getting them back transported and connected with those folks, including veteran services. Next slide, please. Last but not least, just some common questions about what it is that we are currently doing. Frequently asked questions: what time is the court open for entry to the public? Monday through Friday, 7:30 a.m. to 4 p.m. On Sundays, we are open to run our jail calendar, and we're open to the public from 10:30 a.m. to 2 p.m. Court times are 8 a.m. to 2 p.m. every day on the hour from 8 a.m. to 2 p.m. We do have a website. Individuals can always check information about a case and pull up a docket based on name, citation number, case number, tag number, warrant number, and driver's license number. And is the court open to the public? We have been since October of 2020, fully operational. We encounter about 16,500 visitors entry into the court every month. Can you call the court and get information? Absolutely. Our lines route through 311 on a relationship that we have with ATL 311. We get about 11,000 calls every month, and we take those calls, answer them, and route them through the court system. Just for this public safety task force where it concerns public safety for Buckhead. I guess, primary concerns for the city, for the court system, just the messaging that individuals are hearing about what's going on and what they can expect if they come in contact with law enforcement. There is a belief at the current moment that for low-level offenses, there will be no penalty and no interaction for the court system. We are trying to push back on that. Right now, we are running a zero tolerance program for failure to appear on all cases. In 2021, which was, coming out of COVID, but yet still a COVID process year, we had 1 out of every 2 traffic cases go into failure to appear status. We also ran a rather lenient failure to appear resolution process during the pandemic to allow individuals who got traffic citations the ability to resolve that without penalty on their license. We're now rolling that back, making sure that individuals who get tickets actually come to court on their court date to answer for those, especially for the aggravated offenses, individuals who have high rates of speed, individuals who are otherwise involved in any type of street racing or street racing related conduct, whether that's laying drag, burning rubber in intersections, as well as any of the criminal conduct that may be related to any of those incidences. This also includes licenses and hours of operations, cases concerning establishments that are open at night that also sell alcohol. Those cases, if there is a failure to appear, there will be warrants generated that will move through the system and be placed on GCIC. So we are trying to do our part as we come out of COVID to drive the messaging that Atlanta's not a free-for-all for any type of behavior and anything does not go. I am happy to take any questions that I may. I believe the next slide is the end slide, and answer any questions that you may have.
Well, we certainly have our share of bad behavior with traffic violations, whether it is laying drag, whether it is excessive speed. It has plagued us. And so I am very glad to hear you say that the court is addressing this seriously, because it is a major driver along with the violence that we have in this part of the city. It is up and down Peachtree Road, all hours of the night, on the interstates. It is outrageous what has been happening to have our citizens feel like there is no control, and there is an awful lot of mayhem that seems to just continue over and over and over again.
Mary, can I ask, do we as a panel think that the court has been effective in reducing drag racing?
I think we ought to ask the court what they're experiencing and what the penalties are.
Yeah, so, and I'm glad that came up, because even touching on what the 2 previous presenters spoke on, especially the chief magistrate, one of the things that we're taking a very serious look at now is the state law regarding releasing individuals on their own recognizance. And that is in the past, a very serious judicial function, not because it is a means to punish before punishment is appropriate, but it also is a means to look at a case, to make a determination on what needs to be put in place to make sure an individual who has been charged with an offense does not simply go back out and reoffend while a case is pending. So for a lot of the cases that we see that would be ordinarily cases that a judge would take a look at, some of the cases that regard what folks are doing on the road, on paper, they are signature bond eligible offenses if the defendant has been arrested under the current law. So those folks never even make it before a judge before they're released. And that's something that we are taking a look at. As a part of our commitment and our zero tolerance policy, if you fail to appear in court and you have been released on a signature bond under the ordinance, then a warrant will be issued for your arrest for that charge, because you are already out on bond. You've already been released for an offense that you have been arrested for and you have not come to court to answer for that charge. That is what we're doing now in the short term to try to make a dent in some of this behavior. But we're also looking at the effectiveness of the overarching policy and looking at where that intersects with the state law, because there also at this point seems to be some conflict with the ability to carte blanche simply release somebody based on an offense without any type of judicial oversight of the case at all. And that is a big driver of a lot of these repeat offenses for the folks that you're seeing and hearing on the streets.
Mr. Chief Judge, I have a question. Councilwoman Norwood, can I ask my question?
Sure.
I have a question, Judge Portis, about the Restorative Justice Project, which you say is for younger accused, but that young age is age 25 and below. With the proliferation of gang crime, and we hear so much about how older criminals are exploiting and using younger participants to commit crimes, is there any record keeping that's done on the accused that are in the Restorative Justice Program and whether they might get 1, 2, or 2 tries and then no longer be eligible for that program, along the lines of what Mayor Dickens recently announced, the repeat offender program for people who've been convicted of 3 felonies?
Yes, without a question. Before you can go into the program, as well as the process of entry into the program with the individuals who are the case managers inside of Restore Atlanta on both ends, not only is your cycle checked inside of the City of Atlanta system, but your criminal history is checked as well to see if you are a good candidate to actually go into the program in the first place. Because obviously the benefit of completing it is your case is closed as a dismissal because you have completed it. So if you have repetitive interactions with the City of Atlanta, if you have extensive criminal history in other court systems, you are not a candidate for that program.
Thank you.
Thank you, Judge Portis.
Thank you.
Sorry, I mispronounced your name earlier. I want to apologize for that.
Oh, it's no problem at all. Happy to be here.
That was our agenda. Our agenda had misspelled that.
Oh,
So
it's no problem at all.
I
Happy to
take
be here.
responsibility for that, and I do know your name, sir.
Our next presenter is going to be Chief Juliet Scales, and she's going to tell us about what happens in her court and how that's going to help us learn a little bit about how that impacts Buckhead. So Chief Judge Scales, sorry.
Good evening. Thank you for having me. I am Juliet Scales, and I am the presiding judge of the Fulton County Juvenile Court, serving as the chief judge at this time as designated through Superior Court. We have 7 judges in our court, 4 judges and 3 associate judges. We all have the jurisdiction of juvenile court, and that would include hearing all matters involving delinquency, dependency, children in need of services, or otherwise known as CHINs. We also hear transfers from Superior and State Court, as well as emancipations, parental notifications. We have special designation to hear adoptions when there are consistent with what the Superior Court has allowed. I know that I wanted to, give kind of a brief overview of our court in that regard. I know that this task force is focused attention on what would be considered in our category of delinquency cases. I would say that in conjunction with dependency cases, as we often have youth that are involved, as we refer to them as being dually involved, so they may be both dependent as well as delinquent. But our delinquency cases, of course, come to the court by means of a copy charge or by means of a complaint, or child is arrested and then brought before the court. Our court is required to consider, in the consideration of whether or not a child is released or detained, a detention assessment instrument, as well as all other factors and circumstances surrounding that child to ensure that we're compliant with what the juvenile court code, the Georgia Juvenile Court Code requires. In the code, it does outline, of course, the purpose of the juvenile code to ensure each child is given guidance, care, preferably in their home so that they can be secure. Their moral, emotional, mental, and physical welfare is to be considered. And of course, along with the safety of both the child and the community. We are to follow the guidelines such that we are providing protection of the community as well as the protection of the children, and considering all the circumstances around the case as it's presented, along, of course, with the detention assessment instrument. That detention assessment instrument is one that is utilized not only here in Fulton County, but that is a Georgia requirement, a statewide requirement, and one which is actually nationally recognized as being a part of best practices as we review and consider cases. Each child certainly brought before the court have the same rights and responsibilities, same rights given to them as any adult, in the sense that they are all given rights to have counsel, given rights to have hearings being heard, certainly in an evidentiary manner, and given opportunity then to be notified of what those charges are and how the matter would proceed. Juvenile court is a little different in the processing of cases in that we have strict guidelines that we must follow. Now, during the time in which we've had this emergency public health situation in place, COVID, we have followed, of course, the emergency orders that have been issued, and that has allowed us to, however, continue to hear all of our cases very regularly. We have not had much disruption in the hearing of our cases, as we've heard them both virtually as well as hybrid through the course of the time in which we've had the emergency orders in place. We, of course, work directly with the Department of Juvenile Justice, along with the Department of Family and Children Services. And so the Department of Juvenile Justice has been instrumental in ensuring that we're able to comply with the statutory requirements of having those cases heard timely. They have provided the virtual access to the youth so that they are able to participate in those hearings, even though they may be continue to be held in a DJJ or Department of Juvenile Justice facility. So as we have, I'm sorry, I don't know if I'm having an echo or not, but as we have considered those cases, I know that there has been previously a lot of discussion around the release or detention of youth, the use of restricted conditions upon them. And I believe Ms. Commissioner, is it Councilwoman Norwood, has indicated that this group has some interest in understanding where we go from here in terms of where we are and what our needs may be through legislation. We certainly are compliant and consistent with what is provided in the law and what's required of us. Much of what we rely on in terms of restricting and supporting youth while they're in the community, either pre-adjudication or post-adjudication, relies on what's provided through the Department of Juvenile Justice as they provide us with alternatives to detention to ensure youth that can be released back into the community, either pre or post adjudication, are done. That is done with those restrictions in place, monitor or other tracking. That's provided through the state to support those cases that are coming through Fulton County Juvenile Court. Our court, again, has its own DA assigned as well as public defender assigned. We have senior officers of those agencies that we work directly in conjunction with. And both of those agencies have been instrumental in ensuring that we have continued to keep all of the cases that are being presented through juvenile court moving forward consistently and not having any real form of backlog during the last 2 years that has plagued all of us. I do want to also mention, as cases are processed and children are brought before the court, that we also have alternative programs that we address youth with, that we have first-time offenders program, we have the Community Restorative Board, we utilize informal conferencing as well as mediation services. Since the At Promise centers have made themselves available, we have 2 locations, I think now, we also have continued to utilize those services that are in place to provide therapeutic support. We are very much engaged in providing evidence-based services, evidence-based treatment as it relates to the programming provided for children as well as youth. Most recently, last year, I would say actually the June, I believe it was June of 2021, we were able to obtain an assessment of our court and our process that was done by the National Council of Juvenile and Family Court Judges to assess the court so that we can develop and be better able to provide trauma-informed and trauma-responsive services to citizens that come before our court. So we have been engaged in that process most recently to try to ensure that we're meeting the needs of the families and children that we serve. In our court, we have developed specialty courts and accountability courts as well. And I just want to mention those also because we have had a history of having, of course, the family treatment court, the drug court, but we also have, in addition to that, the juvenile drug court, which is not identified, is known as Choices. We have a truancy court. We have also previously had both a peer or teen court as well as a mental health court. Both of those courts are currently inactive. However, we have developed recently and just had a recent kickoff of the Ascend Court, which is the juvenile high-risk youth court. It is a court designed to provide more intensive supervision and services to youth that would otherwise be moving forward and moving toward commitment to the Department of Juvenile Justice in a more restricted manner. The idea is to utilize services within the community to support and provide for those youth with intensive judicial oversight so that those cases would come before the court on a most frequent basis. We have specialized probation that will be assigned along with clinicians that will be working with those youth to ensure that we've given every opportunity for those youth to be rehabilitated and to be restored to a productive citizenship prior to the commitment to the Department of Juvenile Justice. I presume most of you know, but I will say that it certainly is of great concern when in fact commitments to juvenile justice are ordered and even custody transfers to the Department of Family and Children Services are ordered when judges do not have the authority to make any more placement decisions other than that. So the court will order the Department of Juvenile Justice have custody of a youth, but it is the determination of the Department of Juvenile Justice as to whether or not the child is then subsequently released into the community for services to be provided by the Department of Juvenile Justice or placed in a more restricted placement. Now, there are cases in which they would certainly qualify and fall under the statute guidelines to allow the judge to then order straight commitment, restricted commitment, if in fact those are designated felony acts that have occurred and other criteria has been met based upon what the statute requires. But our orders in terms of disposition would include both those commitment orders to the Department of Juvenile Justice, as well as probation, of course, provided in Fulton County by our independent probation office. Probation per statute is limited to 2 years of probation unless it is by request of the DA extended. And so there certainly can be an extension of those probation orders. However, the maximum typically for probation is 2 years. And our court's jurisdiction would no longer, would be no longer after the child reaches the age of 21.
Chief Judge, we have a question in the chat from Rick Hamilton. Rick, if you'd like to ask your question.
Okay.
You're
I
muted.
said, what percentage of your youth are suspected to be in a gang? And are you having any success in separating them from their gangs?
I cannot honestly speak to you regarding percentages, but that is certainly something that I may be able to gather. I do have with me my chief administrative officer, but I don't know if he has that information either. But I will tell you that we certainly have seen an uptick in the filing of cases for charges of participation in gang activity. There definitely has been an uptick in those most recently. As far as separation from a gang, are you having any success in separating them from their gangs? What I will tell you is that we have now designated, as I indicated, the Ascend Court, which is a new program. We've just launched that program. It will be modeled after, or is modeled after, a couple of the second chance courts around the state. And it is also modeled, there is also influence, of course, nationally. That court will be one that will incorporate those that may be believed to be in gangs, to address that gang behavior, and also to work towards certainly the goal of separating or addressing that. But that is a part of what probation, our probation department addresses. We do have specialized training that the probation officers have undergone, and most recently have been involved with that training through some of our other law enforcement agencies to try to give them more information as probation officers to try to, first of all, identify those that may be participating in gang activity, give them other options and resources on how to address that, and also incorporate the gang awareness programs that are developing around that issue.
Chief Judge, I want to ask one question that I have heard over the years, and I want to know if it's true or not. The instrument that y'all use, the assessment instrument, I think is referred to as the point system. My question is because I have heard again over the years that because it's a juvenile, that information that has been accumulated in previous offenses with the points is not applied in a successive case. Is that incorrect? Do you keep track of how many times a juvenile has been charged with one of the offenses on that assessment, and that becomes cumulative rather than starting over with each new case?
The detention assessment instrument, the DAI, is an instrument that's used statewide. It has national origin. It is an instrument that is cumulative in terms of the number of contacts the youth has had with the court. What those contacts are, there are several parts of that assessment that work together to have then the score. When you talk about the points, there is a score that is basically the number. There are several questions, and I guess the short answer to your question is yes, it is a cumulative assessment tool that considers the child's history. It also considers the child's background and circumstances. And that is all contained within that assessment that's then provided to the court as one factor to be considered as we make determinations regarding whether or not the child should be released into the community, or whether the child should be released with restrictions, released with conditions, or detained. And if detained, certainly there are then other action that must be taken most immediately, because juvenile court has mandatory guidelines regarding the time limits in which things occur. Our juvenile court here in Fulton has a 24-hour intake office, just as I believe maybe it was the chief magistrate mentioned, a 24-hour, 365-day court. We are of the same in that regard. The court is hearing cases or receiving those complaints and charges 24 hours a day. Judges are on call 24 hours a day, including weekends and holidays. They are given that DAI, detention assessment and instrument information, along with the facts of the case as they are alleged on on the complaint in order to try to make those decisions. And of course, considering the background of the child, the home life of the child, you know, all of the factors that would come into play in order to make that decision. I hope that's
Thank you.
helpful. I hope I've answered your question.
Now, it's of great concern to me that there are adults that are using very young teenagers or younger in some of the crimes that are being committed. That is of great concern and always has been. So it's one of the things that I would love to get, again, from all four of our chief judges, your recommendations for us to include in our report that we will be putting out in May, and work with us on that. We want it to be as comprehensive but concise as it can be, so that it actually will be an action report rather than 60 pages of information that no one ever reads. So thank you. And back to you, Madam Chair.
Mary, Madam Chair, may I ask a question?
Certainly.
So I listened to first of all, I know some of the judges in passing, and I have eminent respect for them and their skills and their wise decisions. But when I hear their descriptions of how their courts function and what's going on, I feel this disconnect with what we're being told by the police department and others. The policemen tell us that they're arresting people, and by the time they have the third or fourth person they arrested during the day booked, the first one's already back out on bail. They're telling us that even the indicted cases don't get processed through the Superior Court system quickly enough, and it just makes things more difficult for everybody involved. Cop policemen leave, they aren't there to be witnesses by the time the case is tried, and it just complicates things generally. Any sense for why there's this, I perceive this disconnect between what the police are telling us and what we're hearing from the courts tonight?
I'd be happy to step in and give you my 2 cents on it, if that's helpful. This is Chris Brasher again. First of all, I'm not going to be so presumptuous as to say that either perspective is wrong. I think the reality is that law enforcement gets frustrated with the courts, and let's be honest, the courts get frustrated with law enforcement. That's just the way it is. The reality is that if a police officer arrests someone and they get released on a bond, whether that's in their view appropriate or not, it can be frustrating to them, especially if they had to work very hard or put themselves in harm's way to do that. I completely understand. The reality also is that cases take a long time to get through the criminal justice system. I've been on the bench for 16 years. I've tried probably 250 jury trials. Somewhere around 100 of them have been murder cases. Those are the most difficult cases we try. It often takes 2 weeks to get one of those cases tried. So the reality is that those are the cases we try more than anything else. So I often say, and it's not a joke, that if we're not trying a murder, a rape, an armed robbery, or an aggravated child molestation case, we're doing something wrong, because those are the most serious cases we have, and they're the ones that take the longest to try. They're also the ones that take the longest to investigate and to present. So if we begin with that hierarchy, it becomes clear that no matter how many judges you have and how many prosecutors you have, it's going to take a long time for those cases to get through. And yes, law enforcement officers move on to another department or they retire. Same thing with prosecutors. Those things make cases take a long time. I'm not here to offer any excuses. I'm just here to hopefully give some perspective, that it is the perspective of the speaker that should be taken into consideration when you hear what their complaint is. I'm not going to complain about police officers because I respect what they do, and I know police officers are not going to, or law enforcement officers are not going to complain about specific judges because they respect what we do, but they also recognize that there are things about the system that frustrate them. So, Chris, is there a disconnect? Perhaps, but there is also the classic perception issue where somebody sees it from their end and the other sees it from the other.
What sort of statistics do you use to measure the efficiency of the court? Do you have a count of how many days on average it takes from when the case is turned, I assume this from when the defendant's arraigned until when you do your pretrial to when you do your trial? I mean, how do you measure performance when you're efficiency? Because efficiency and performance are two different things in a situation like this.
So from a performance standpoint, we measure closure rates. That is almost universally accepted as a way that courts measure their performance. And generally, you want a court's closure rate to be at or above 100%. What that means is that we're putting out the door the same number or slightly more things that are coming in. The other statistics that we look at are the length of time that it takes for particular cases to work their way through the system. And there are national standards promulgated by the National Center for State Courts that talk about lower level offenses taking 90 days, mid-level offenses taking 180 days, and high level offenses, murder cases, et cetera, taking a year or more. All of those are subject, those are not hard and fast rules, but they're general guidelines. So basically, from a statistical standpoint, you'd want less than maybe 1 or 2 standard deviations on either side of those as you move through the system. The reality is that
I'm going to interrupt. I'm going to interrupt Mr. Dickerson because we still have Scott Crayer with the MARTA police.
Okay.
So to be continued, but thank you for your question. Thank you. Very
Chief,
important.
I'm sorry for stepping on your toes.
No, not at all, Chief.
Okay, and Scott, we will have your presentation, and then we will finish it up with the finishing up questions.
Okay.
And we will give everyone email so that conversations can continue.
Council member, it's good to see you again. Good to see Sarge again. Just a real quick shout out to the Zone 2 Buckhead Commander, Andrew Sinzer, who was promoted today to Deputy Chief. Congratulations, Andrew. Well deserved. Well deserved. For those of you who don't know me, I'm Scott Crayer. I'm the Chief of Police for MARTA. I did 27 years and retired as a Deputy Chief for the Atlanta Police Department in 2020 and took over the MARTA Police Department right at the cusp of COVID-19. Very interesting time to take over a police department. Next slide, please. Just to give you a little snapshot of what MARTA is and what the history is, it was formed in 1971 as a bus-only system. Heavy rail operations began in '79. We're about the 9th largest transit system in the United States with over 38 rail stations, almost 400 rail cars, 600 buses, and of course, almost 300 now mobile vehicles, which are our mobility vehicles, which are our ADA vehicles that transport folks around town. We have 114 million independent passenger trips annually with about 400,000 daily. Of course, we do serve both Fulton, DeKalb, and Clayton counties throughout the system. Next slide, please. This is our rail system map, and in the circle, it's a little small, but you can see the designated area there for Buckhead. We have our 3 main stations, which is Lindbergh, Buckhead, and the Lenox Square station. Next station, next slide, please. Our organization consists of 454 full-time employees. Of that, 346 are sworn. We have 4 precincts throughout the system, 1 headquarters right on Piedmont. And then, of course, we have our IOC and EOC up the Shamley station on the north end. We consist of a normal traditional police department when it comes to, we have SWAT, tactical field officers, our motorcycle unit, bicycle units. We have K9 that work the entire system. We have members with the JTTF, the SURF units, which are the Marshall Task Forces, and the FBI task forces. And of course, we have an undercover detail that works our system every day. My current fiscal year 22 operating budget for my police department is right at $40 million. Next slide. My two deputy chiefs, Pearlie McKenzie, just came over as the administrative deputy chief in January, and Michael Burrows is now the operations chief over our precincts also in January. Next slide. Frederico Jackson is your precinct commander for Buckhead. His office is out of the Dunwoody station, but he covers all the way to the north end of the rail lines, and he stops all the way down at Lindbergh. Next slide. And then Mr. Willie Davenport is our major over special operations. So anything we do outside of our normal duties in the precincts and on the platforms, he handles our undercover details, our bicycle, all those specialty details you saw on the previous slide. Next slide, please. So as you heard from everybody on the call here, COVID really struck us hard. At the beginning of 2020, since now, we've lost 63 sworn positions due to resignations or terminations or retirements, you name it. In the grand scheme of things, that's about a 20% reduction in force since January of 2020. The good news is our interim CEO, Collie Greenwood, has committed to a very aggressive incentive plan to hire and retain quality police officers that work for MARTA, and we're starting to see the tide turn a little bit this year. Our biggest challenge is the unsheltered population on the system. Once COVID hit in March of 2020, ridership went down 50 to 60%, both in rail and bus operations, to the point where we began to see our entire system begin to be inundated with unsheltered folks throughout both the rail and bus system. There's really no long-term solutions. What we found, there's not any significant mental health facilities available for these individuals, nor substance abuse places to send these unhoused individuals. Long-term housing, other than the Gateway Center, there's really not another place that we can go to move these unsheltered populations off the system and into long-term care. MARTA did do a significant solution to our system as part of creating what we call the HOPE team. It consists of social workers that we've hired, and we paired them with what we call our field protective specialists. These are unarmed security officers that have a little bit less of an intimidating factor for our unsheltered population as a police officer would. And they work with our unsheltered population to assist them to find services, whether that be through local or state services, or even through the PAD pre-arrest diversion system if we do make a simple arrest. What we're seeing at the end of service, we don't run 24 hours a day. So the rail system and the bus system stops. On our rail system, we see an average of 40 to 60 unsheltered individuals that we're forced to remove from our train system every night. To give you an example, last night, because of the weather, at the end of the line at the airport, but just before the airport, we removed 120 individuals off our system that were unsheltered population. Next slide. So even with those challenges, we continue to be proactive. I think what you're seeing now is one of the best cooperative law enforcement agencies in the region that you've ever seen in my 30 years here. Chief Labatt, Chief Bryant, all the members of APD, the members of the other jurisdictions that we serve. We continue to communicate daily, at least daily, if not weekly, to talk about crime that not only affects us individually, but as a jurisdiction, as a regional jurisdiction that we have to work together. So last year, Major Sinzer and I put together the MARTA Police Department, the APD Joint Bicycle Patrol for the Lindbergh area around Morosco Way, Sidney Marcus, that area. We provided 2 bike officers. Major Sinzer provided 4. And they are still operating today, Monday through Friday from 10 to 6. They really have a significant impact on the quality of life issues that you see around those areas. And I'll let Andrew talk about the statistical part of it if you want to, but I've seen a tremendous decrease in the amount of quality of life issues. They still have a lot of work to do around there. There's a lot of unsheltered population up around Lindbergh and Orozco Way around the Kroger, but we continue to battle that as we move forward. Next slide, please. So our crime initiatives we're working on, when I came to MARTA, we really didn't have an undercover detail that worked on a regular basis. So I have a minimum of 5 undercover officers working the system every day that are supervised by a sergeant. And then because of the unsheltered population increases that we saw over the last 2 years, and that's not just Atlanta, my regional partners around the country and the transit agency world are continuing to see the same issues with the unsheltered population. So we felt it was important to send a message now that we're beginning to come out of the COVID wave here. And I've got the support of the Collie Greenwood, our interim CEO, to really start to push the unsheltered population and those that break the rules and break the laws in our system. So we're beginning a full-blown open to close detail. I think it's going to start Saturday. Got a few more details to work out, but as you see, it will be 4 sergeants, 12 officers, and 2 wagon drivers. And we're basically going to have a zero tolerance on our system. We have what's called a Ride with Respect program, which is a rules-based, not a law-based system where we can suspend people from the system if they violate any rules or regulations on the system. So we'll use that along with our local and state laws to make sure we enforce everything that we can to get our system back to where the ridership wants to come back and feel safe on our system. I allowed our MPD officers to assist with Lenox Mall. When we saw that really come to a head again last couple of years, MPD was not assisting with that. So currently I have off-duty MPD officers working off-duty at Lenox Mall in the parking lots around the back of the mall where the Lenox station is, and in those parking lots that are adjacent to the mall. One of the things Andrew Sinzer did in his career was he created the Tactical Field Officer Program, and this is a fantastic program. APD has been very generous in allowing MARTA to participate in their training program. I have 13 of those individuals trained right now. These are almost SWAT officers. They're not fully certified SWAT officers, but these are the individuals that will be on the line when something bad happens. They can immediately address the issue before having to call SWAT in and wait on them. So I have 13 of those now, got 7 more scheduled to be trained this summer. And then we just had a presentation yesterday by a company called Fusus. And this is a real-time crime fighting initiative that a lot of the jurisdictions, APD is starting to use this. Clayton County, DeKalb County, MARTA will join in if we think this is the right thing, which I think it will be. But basically it takes all the information from the cameras and ingests that information and helps us fight crime. So to just give you a quick instance, if I'm looking for a red Mustang with a black, hard top that's committing crimes in the city, we can put that information in there, and every single camera that is ingested in the Fusus system will look for that car and let us know where it is. It's an amazing system, and I think regionally, I had a meeting with UASI, the Urban Area Security Initiative, our federal partners the other day. They were on the call yesterday. They're very interested in making this a regional effort so that we'll have an umbrella around the entire region. Next slide, please. And I just want to close. I feel like we kind of danced around it a little bit in the discussions. We had a homicide while I was on this call. It was at the 5 Point station, just outside of the station, down by 5 points, and an individual lost his life. And looking at the video, the individual slapped the suspect in the back of the head and walked off, and the suspect turned around and walked up and shot him and killed him. right there. So I think we really need to look at the underlying causes of why we're seeing the violence that we see. These court systems are huge impact to helping us fight this. I've worked with them for 30 years and I have nothing bad to say about them. Our partners in this region are working hard to come up with solutions. But when you see violence like that, I don't know what the solution is for as law enforcement and the court system. I guess we'll see when this works its way through the court what the history is of these two individuals. But that's the kind of violence that we're seeing today. And I'm always looking forward to solutions. I'm happy to be participating in the Atlanta region, Atlanta Crime Commission that should be starting up shortly. But with that, I'll turn it over to any questions anybody has.
Thank you very much, Scott. I just want to also say, you know, you did say that you had been an Atlanta police officer for many, many years, but you do have a particular attachment to the Buckhead area and the North area, because this is the first place that I met you as a new supervisor. So I know how committed you are, and I appreciate it.
Thanks, Sarge.
Well, we are at 8 o'clock, Madam Chair. And if there is a absolute necessary question, we will hear it. If there is not an absolute necessary question, we are going to continue our practice of starting on time and ending as closely on time as we possibly can.
Well, I'm going to close with just a couple more words about these justices that showed up tonight and gave their presentations to help us understand how they're helping crime in Buckhead. And I want to say for Chief Judge Brasher in particular, thank you for the considerate way that you put the relationship between police and courts and how these things tie in together. And, you know, we just have to continue to work on these relationships. They're not always perfect. Probably none of our other relationships are perfect either. But I appreciate you guys being willing to continue to work on these things and help us understand. And in particular, especially with juvenile justice. You know, I had been told by a juvenile court judge many, many years ago, you have to continue to go back. You know, a lot of these officers may not have time, but they do. They need to pick up the code and continue to read it, see what it says, you know, see why sometimes the pieces don't seem to fit together, and how we can continue to work together to make the pieces fit better. And the very last thing I'm going to say before I go way over is I was going to skip past this because I hadn't actually seen a physical order this afternoon, even though I'd heard the news about Major Sinzer being appointed to deputy chief. And I'm so proud of this guy. You know, I feel so, he's been so important to this committee and to this task force. And I didn't want to jump the gun or, you know, throw a wrench in it or anything. That's why I didn't say anything at the beginning. But congratulations, many congratulations, Major Sinzer, Deputy Chief Sinzer. That's work well done and an appointment well deserved.
Absolutely.
Thank you. It really has been an honor to serve as the commander of Zone 2. My 26 years, this has probably been the most challenging assignment that I've had. I'm moving into another very challenging assignment as the deputy chief over strategy and special projects for APD. So, you know, I look forward to serving the city in that way and helping us fight crimes a little bit behind the scenes with getting some big projects done. So I'm not going to be a stranger to anybody here. I'm a phone call away. I'll certainly miss my close relationships with everybody and speaking with everybody, you know, on a weekly basis. But thank you for the acknowledgement, and I appreciate it.
You're very welcome.
Madam Chair, before we do our motion to adjourn, I did want to let folks know Councilmember Shook was trying to get on and had a technical issue. He wanted to let folks know that he was trying to get on.
Thank you, Councilman Shook. And I guess we'll hear from him maybe at the next meeting. All right, well.
Madam
I'm
Chair,
sorry.
if I could, this is Deputy Chief Peak, and y'all please forgive me. I was out this week, but I didn't want to miss the meeting, so I pulled over and made sure I could get on there, but was trying to wait in line to ensure that we did lift up Major Sensor's promotion to Deputy Chief, and we're certainly ecstatic about that, and I know that he'll do an outstanding job. I do want to share with this group that his replacement as well will be Major Aileen Mitchell, who was Major Sensor's assistant not very long ago. So we believe that also that he'll be able to step into the shoes and carry on all the great work that's already been done. And they already have a great understanding and a great network, and he's familiar with the Buckhead community. So we believe that you all will still be in great hands, as we believe that APD is a great agency, and we actually always strive to put the best out there. So just want to really share that piece with you, and congratulations again, Andrew.
Thank you, Chief Peak, and we'll look forward to talking with Major Mitchell and welcoming him soon.
Absolutely.
So I'll make a motion to adjourn the meeting.
Second.
All right, we are so adjourned.
Thank
Thanks,
you.
everybody.
Take care, everyone.
Thanks, everyone.